Good day. My name is Michael MacHarg. I'm an attorney here at Adams & Reese in the Labor and Employment Department. I'm going to talk to you a little bit about the Biden administration's labor imperatives, changes that are on the horizon. Much of this might be material that you've seen discussed before or analyzed in a different way. I hope to deliver this from a slightly different perspective and talk more about the pragmatic effects of what's going on within the administration rather than giving a sky is falling approach. Some housekeeping matters before we get underway. Obviously, we would love for this to be as interactive as possible under these circumstances. So if you have questions or comments, we would love to make sure that we address them. You can type your questions into the portal. Only one of us will see them, and I will get answers back to you as quickly as I possibly can in the event that somebody has a question. And obviously, I'd love to take the time to speak to everyone and get to know you and give you my viewpoints on labor relations. Also, at the end of the presentation, there will be a badge for you to download to get you credit for the attendance portion of this matter, and I know everybody wants to get credit for their CLE. So with that, let's talk about the major Biden administration initiative, and it's called the Protecting the Right to Organize Act. The PRO Act, as it's called in shorthand, is a very controversial piece of legislation that has been kicking around Congress for 4 years now. It has passed the House on 2 separate occasions, including February of this year. It has not yet come up for a vote in the Senate, but it does have 44 Democratic sponsors. So there is support for the notion of this PRO Act. And quite honestly, the entire PRO Act issue will come down to whether or not there's the political wherewithal to eliminate the filibuster. If the filibuster remains part of the Senate's parliamentary procedure, there is absolutely no chance the PRO Act will pass. However, as I stated, I wanted to discuss this from a somewhat more pragmatic standpoint because I think there's a high likelihood that bits and pieces of this legislation will be horse traded in an effort to give the unions some of what they've been looking for from this administration. And Joe Biden has stated that he wants to be known as the most pro-union president in the history of the United States. Part of his background being from Scranton, Pennsylvania, part of his belief system, and consistent with how he's acted as a civil servant for over 40 years. I don't want this to be political nor judgmental. Again, I just want to talk about it from a practical standpoint so that when you're operating and managing your businesses, you have some idea of what to expect and can answer any questions or take steps to avoid problems before they get started. The proposed legislation is quite simply the ultimate Christmas wish list for unions. Everything that any union representative ever that they could have dreamed up is in this rewrite of the National Labor Relations Act. Now, there are other parts to the statute that are not directly related to the National Labor Relations Act, but for the most part, the PRO Act is a complete rewrite of the National Labor Relations Act from top to bottom. And candidly, if it were passed precisely as proposed, it is very unlikely that management would ever defeat another union organizing drive. It is, in short, management's worst nightmare come true. Now, the first area that is going to be impacted by the PRO Act would be changes to the way unions organize, how unions go through the exercise of organizing employees. The manner of union organizing will change entirely. In general, as many of you know, right now the process begins with the union soliciting authorization cards from employees. They try to get over 50 or 60% of the cards, and then they present them to the labor board, and there's an election. You can do it with as few as 30% of the cards, but unions like certainty, so they typically seek to have about twice as many as the bare minimum. This number will become very important if the PRO Act were to pass in the future, because if a union has a majority of the cards under the PRO Act and an employer wins the election but is found to have committed unfair labor practices, the PRO Act will automatically install the union as the representative of the employees on the theory that only the employer's interference prevented the majority of people who signed cards from exercising their free will. Another organizing change that's very, very important is it codifies the California and Massachusetts ABC test. I like to call the ABC test the I hate Uber portion of the legislation. In the history of labor relations, I have not seen one company more vilified by a political group than Uber seems to be at the state and federal level. They simply are unpopular on Capitol Hill, and they want to eliminate the ABC. The ABC test would eliminate essentially independent contractors entirely from the concept of labor law. So you would no longer be able to exclude employees from having an election or from a bargaining unit because they were independent contractors. That would be repealed entirely from the National Labor Relations Act. Another difficulty will be an employer will be heavily restricted in their ability to seek legal advice regarding responding to the union or avoiding the union. The PRO Act would require that all of the financial expenditures to law firms, consultants, whomever, must be explicitly reported to the unions and the employees in real time. This would have an obviously severe chilling effect on an employer's ability to seek legal advice. One of the last and most controversial pieces of the legislation is this question of electronic systems access. This is an area of the law that has been controversial now for at least 40 years, if not longer. And it's the question of whether or not a union has a right to use an employer's email or other electronic systems for the purposes of organizing the workforce. Now, I take a minority view. I would think that many, many management lawyers would disagree with my perspective on this. But I'm perfectly okay with unions getting access to our email system because hopefully we all have sophisticated policies that allow us to review our emails and the emails that go into and come out of employee email boxes. If the unions are going to give us their strategy for free without any way to prove that we looked at the email, my advice is to take advantage of it. I know there are a lot of true believer management types that would never, ever want anything at all to give the unions a leg up, but this one to me is a wash if you take an advanced look at your policies and make sure that you're keeping current on managing your electronic systems day to day. The far more interesting question to me, one that I don't think they fully thought through when they passed the PRO Act, drafted the PRO Act, was the issue of Zoom or Teams or whatever type of electronic meeting place. Presumably, if an employer has a Zoom account under the PRO Act, unions would have the right to utilize the employer's Zoom platform for the purpose of organizing. This would upset many employers and is an infringement on an employer's property right and could create sticky and difficult legal issues down the line. The second part of the changes to union organizing, no more right to employer free speech. Currently, under the National Labor Relations Act, just like in the United States Constitution, an employer has the right to speak freely on its opinions about organizing with its workforce. That would be entirely repealed. I have personally serious questions as to whether or not that would pass muster under the Constitution, but the PRO Act as written would abdicate employers' ability to speak freely with its workforce regarding its opinions on the relative merits of unionization. Similarly, employers would no longer be permitted to hold meetings with its employees to discuss union organizing and give its viewpoint on why a third party is not in the best interest of the target organization. As I mentioned, another chilling effect would be the reporting on the cash expenditures for legal advice, consulting advice on union avoidance. And the last one that is controversial, has been controversial in the current sense. When a union petition is filed, the employer has to turn over the names and addresses. Under the PRO Act, the minute the union expressed interest in organizing the employees, employers would be required to disclose to unions the name, address, email, cell phone, every shred of personal information about a potential voter to the union to assist them in reaching out to the employees and try to convince them to organize. Without the employer having any ability to rebut this, it can easily be seen how unions will basically just be scrimmaging against themselves in the union organizing context of the future under the PRO Act. There are changes with respect to supervisory status as well. The PRO Act changes the definition of the term supervisor. Presently, there's a 12-part test, and if a supervisor meets any of those 12 parts, they're deemed a supervisor not eligible to vote. Our supervisors are our key components in communicating with employees, and eliminating supervisory challenge will present tremendous difficulties for employers in any effort to get a message out to the employees that unionization is not in their best interest. The PRO Act directly eliminates assignment of work and responsibility to direct work of other employees as any part of the supervisory test. Those are currently two of the disjunctive 12-part tests. It also would require for the first time that a supervisor spend a majority of their time supervising, not simply having the supervisory authority and exercising it with regularity. The next area that the PRO Act seeks to alter is elections. The employer would be removed for the first time since the statute passed in 1935 from the process entirely. Employers would no longer have any say in who is an eligible voter, when the election is going to be held, or where it's going to be held. The union and the National Labor Relations Board become the sole arbiters of how the election will play itself out. Again, I do think this raises a constitutional issue if the National Labor Relations Board attempts to force an election on an employer's private property. Just like the police need a warrant to come in and search your premises, I'm a little dubious about the ability of Congress to force an employer to open its property up, private property up, to do the business of an outside third party. And finally, the appropriate bargaining unit determination would be made without any input from the employer. What would get complicated here, as I mentioned, sort of in the I hate Uber section of the law, there will be copious joint employer issues moving forward. If you used temporary employees, for instance, in your business, it is very likely that the workforce would be eligible to vote alongside your regular employees. The joint employer issue has been hot button topic for a couple of years, largely because of McDonald's and whether or not a McDonald's franchise is also McDonald's the corporation. And of course, unions desperately want to reach into the deeper pocket and have the parent McDonald's and the franchise McDonald's operate as a single unit. Last but not least, we would have this question of micro units. And this could be very difficult depending on the type of operation that your company has. If you had a typical production and maintenance unit now, typically every employee in production and maintenance is eligible to vote. However, under the new standard, the PRO Act would allow for micro units, and you could literally have just a unit of janitors, or you could break down a hospital nursing group into just surgical nurses, for instance. You would be giving unions almost instantaneous foothold through these tiny units that was passed for a period of time under the Obama administration, but is currently back as a political issue, and micro units presently not readily accepted under the law. The conduct of the election would also be determined solely by the unions and the NLRB. We would have a lot more mail ballots, which are very difficult for management to respond to because of the 2-week period of time that they can't communicate with their employees, though under the PRO Act they wouldn't be communicating with them anymore anyway. There's the question of whether or not they would order on-site elections and whether or not they could legally. And perhaps the most interesting question is the potential for future electronic type voting, something the technology doesn't exist for just yet, but is being contemplated by the PRO Act and in this revolutionary change. One of the hardest hit areas in the PRO Act, and probably the most unnerving, are the changes that will be happening to the collective bargaining process. Break this down into two categories. First contract, you have no union, a union comes in, they win the election, now you have to negotiate with the union. The PRO Act would apply. You would have a 10-day time limit. The union could then demand the Federal Mediation and Conciliation Service come in. That would trigger a 90-day time limit. If the parties did not reach an agreement within that 90 days under the FMCS, a formal trial, what's known as an arbitration, a tripartite arbitration, there would be one arbitrator selected by the management, one selected by the union, and then the two other arbitrators would select the third party. What's difficult about this is it's what's commonly known as interest arbitration. It's also sometimes known as baseball arbitration, and it would essentially make the issue of whether or not the parties have a collective bargaining agreement come down to a trial. The tripartite arbitration panel would impose a 2-year collective bargaining agreement based on the evidence presented at the trial. What's particularly alarming about this provision is that management would be required to disclose in a discovery type situation financial information that it presently has no obligation to disclose whatsoever. The union would get a very, very deep dive into the company's financials, and this obviously would create problems for companies and their relationships with employees going forward. With respect to the collective bargaining agreement, where there's an existing agreement in place, the enormous change here would be that an employer would no longer have the right to declare impasse and implement the terms of its last, best, and final offer. Rather, the extant collective bargaining agreement would continue by its very terms continuously until the parties were able to reach an agreement. Just as importantly, an employer now would be stripped of its right to withdraw recognition from a union that it has evidence no longer represents the majority of its employees. Presently, employers are permitted, if they have objective evidence that a majority don't want the union, they can withdraw recognition. Under the PRO Act, that practice would be prohibited. The next area that would bring some wholesale changes, and is probably one of the more important pieces of the PRO Act, is how strikes and secondary activity would be handled. I taught law school for several years, and I always explained to my law students that really the question of strikes determined what kind of collective bargaining agreement you would get before the parties even sat down at the bargaining table. If the union had the wherewithal to pull out all the bargaining unit employees and go on strike, they were likely going to have the upper hand and get a stronger contract. On the other hand, if an employer is in an area of the country where strikes are not real popular and the employees can't afford to miss a few paychecks, it is likely that the employer will impose its will in the collective bargaining process on the unionized workforce. All of this would change under the PRO Act because permanent replacements. Employers are now privileged and have been since the Supreme Court ruled in 1947 that they could permanently replace employees that went on strike for the purpose of continuing to operate their business. This would be completely proscribed by the PRO Act. In addition, partial and intermittent strikes, which are presently unlawful activity, and you can get fired for engaging in those activities. would be permitted. So unions would be able to call a strike in one department one day, or maybe one department for 1 hour and another department another day or another week. You can imagine in a shipping business how this could wreak havoc by having a slowdown and partial strike in a shipping and distribution department during a key shipping season. The last thing that would create chaos under the PRO Act is that secondary activity, which is currently prescribed. You can't embroil a non-party in a labor dispute. You would be able to then ask the public at large to engage in a boycott against the company that it simply does business with. So take, for instance, UPS. If there was a labor dispute at UPS, unions would be able to ask consumers to boycott companies that UPS shipping, or to picket them when they're on site. It would change the dynamic and the balance of economic power, putting all of the economic weapons in the arsenal of the union and taking away all of the defenses from management. The next thing I'd like to talk about is possibly the most interesting, and I think this is, I bring this up because I think this is the segment of the statute that's most likely to pass in some form in a brokered bipartisan agreement if there's going to be any change to the National Labor Relations Act at all. It has long been said that the National Labor Relations Act penalties for violations are largely ineffectual. This contract would make wholesale changes to that. First of all, an employer would no longer receive an offset for any back pay earned by a discriminatee deemed entitled to a unfair labor practice penalty. In addition, they would receive front pay for a period to be determined. Next, they would be entitled to consequential damages. As of this time, the consequential damages have not been defined under the PRO Act, but we know somewhat what the concept looks like when we think about tort actions and other areas of the law wherein consequential damages are an ordinary part of a damages packages. Add to all of this, there would be a liquidated damages provision. So you would take those first three damage areas I mentioned and now double them. In addition, there would be a civil penalty for each violation, and it could be as much as $50,000 per violation. That number doubles if the employer has repeated the type of violation of which it's accused in recent history. So you could have hundreds of thousands of dollars in penalties in a fairly straightforward and simple case that previously probably would have settled for less than $3,000 to $5,000. The amount of penalties would become quite severe under the PRO Act. Other interesting things are, currently the National Labor Relations Board is the exclusive decider of whether or not to pursue unfair labor practice charges. Under the statute, individuals would have the right to hire their own lawyer and go to federal court on their own after 60 days. This will clog our court systems even more miserably than they already are. There is also recognition that there will be individual liability under the National Labor Relations Act. It would apply to directors and officers who took individual action to commit the unfair labor practice, or who established a policy deemed to have been an unfair labor practice, or know of an unfair labor practice but failed to correct it. As I said, the upshot from all of this is the time for you to put your preventative measures in place and talk to your employees. I thank you for your attention. I will look forward to any discourse regarding questions you have. Thank you for attending the ARHR Summit, and have a good day.